Does it show she's even connected?
No, she's not connected to audio. I just-
I guess.
she's actually-
Yeah.
I realized-
Unmute yourself because you're on this one also. The next one we're gonna do is Greening and Boyer.
You just step around the corner. I'll put that for me. I think
Ms. Wiersma, mute yourself, please. We're gonna take your next. You were not available when we first were here, so please mute yourself and you're the next hearing as soon as we're done with this one.
Oh,
Mr. Boyer, can you hear me?
Your Honor, may I see?
Yes.
The notice specified that it would be, in person, so it looks like Mr. Boyer is trying to reach the courthouse.
Oh, it shouldn't have said it was in person. It said it was on Zoom.
Right, and I just this morning told him I thought it was in person, so this is my mistake. I just, am explaining why he seems to be.
He can be in transit. Sir, can you hear me?
I can.
All right. We're here in the matter Greening versus Boyer. The parties are present by Zoom. Let's see, Mr. Hexel represents Miss Greening. Mr. Browning represents Mr. Boyer. Mr. Browning is in the courtroom. Everybody else is on Zoom. All right. This is the plaintiff's motion through Mr. Hexel regarding Hazel, who's 12 years old. A couple of motions, if you will. Mr. Hexel, you object to the fact that the order that was submitted did not comply with the court rules, basically saying it was a recommended order as opposed to a order that was just signed. It was a recommended order. I'll set aside that prior order and counsel, if you just resubmit it with the language that says it, you know, for de novo review and this kind, the stuff that goes with a recommended order by the referee.
Okay, he was objecting to my response.
What do you mean? He's objecting to your response? It doesn't matter. The order wasn't appropriate. Okay.
I think that it was his order. We're
Was that-
moving around and it's confusing. The moving party is on Zoom.
The moving party's on Zoom. I have Mr. Hexel.
Yes, Your Honor.
Mr. Hexel, excuse me, move the court for relief from that order. Correct?
Correct.
And you drafted the prior order. It was your motion for Mr. Boyer. And
The
you,
motion for change of parenting time.
yes, and you drafted that order and
Yes.
sent it in, okay?
Yeah,
And Mr. Hexel objects to it because it wasn't a proper order. And he's right, it didn't contain the information that it's supposed to contain. It's a referee recommended order as opposed to a court order. I mean, it has to go up to the court. He gets a certain amount of time to de novo and things like that. All right. So that prior order will be entered, but it will have the appropriate language. Okay. So I'll vacate the prior order, but it will have appropriate language as if it is the recommended order. That's what you're seeking, right, Mr. Hexel?
Correct, Your Honor.
All right. There's also a couple of other things that have been requested by you. Prohibit the father from discussing court proceedings and stuff like that, correct?
Correct.
Mr. Boyer, that should go in the order. I mean, what do you have to say about that?
should I address her, Mr. Boyer?
You should address it. You can stay seated. It's all right.
Okay, Your Honor, I would dispute that he's been discussing.
I'm certain you will. And what it really comes down to is I want that in the order. No one is to discuss the case and whatnot with the kid. All right, with
Yes,
Hazel, period. Mr. Hexel, that goes for your client too.
Yes, Your Honor.
See, Mr. Hexel, anything else you want to address at this point?
Briefly, Your Honor, since the parties were here on May 3rd, the child's situation has kind of deteriorated. She's been experiencing panic attacks. She's attended therapy. The therapist has recommended that parenting time be suspended until an assessment can be done. We filed this matter via ex parte motion. Judge Gardner was reviewing Judge Hillary's orders that week. She denied it and said we could bring it before the court on a regular motion day. She did warn Mr. Boyer's counsel that if he talked about this matter again, that he would potentially be looking at a suspension of parenting time. It's my understanding that at least 2 times after that, he's talked about the case for the entire ride home when he's picked up the daughter. He's telling her things like, I'm going to protect you from your mother. What is your mother doing to cause these panic attacks? This is having a detrimental effect on the child. She's continuing to struggle in school. She did poorly on tests after this. At this point, what Ms. Greening is seeking is that Mr. Boyer and the child participate in some therapy together to repair the relationship and potentially take a quick pause on overnight parenting time. She's not asking that the child not see Mr. Boyer at all, but the anxiety is really increasing at nighttime. So she's asking that we do some sort of daytime parenting until we can get this worked out. So that's what we're asking for today, is that the parenting time be modified so that he has daytime with the child, that they go to counseling and they work on this together while the front of the court recommendation is pending.
All right, Mr. Browning, your response.
Thank you, Your Honor. It's really all based off of testimony that we can't get because this is a minor child. But what he's talking about today is substantially different than what was in his ex parte motion. That was regarding a whole lot of other things, and now we're focusing on the specific issue of whether or not my client has discussed the case at all. I think that given the many things, such as last week, I think it was 2 weeks ago. Well, let me start with this. There was an ex parte motion made after your last ruling.
Judge Gardner denied an ex parte.
Yes, but she approved it in part in that my client was not to interfere at all with the minor child's phone. And then in the resulting weekend parenting time, opposing party turned the entire weekend into one long phone and text conversation with the minor child, who is wearing the phone around her neck like a lanyard. And that resulted, I think, that the stress put on the minor child by the mother caused her to have a panic attack. Since that time, we have had 2 successful Wednesday evening parenting times with no problems whatsoever. That was a 1-day thing. I don't think it's fair to pin any perhaps.
But I'm not going to be able to figure this out whether or not he has or hasn't or whatever here on Friday, quite frankly. I know he denies it and I know they say it happened. And I don't, I'm sitting here going, geez, I wasn't in the car. All right.
Right.
And I'm not going to suspend his parenting time. I can tell you that right now.
Thank you.
But Mr. Hexel has kind of offered a olive branch, if you will, that it's during the day. All right. And I think maybe we can have an evidentiary hearing on this overall matter of parenting time. But in the meantime, I guess I'd just revise it. I'm not going to have him overnight parenting time, but he'll get every Saturday. You're going to get every Saturday, 10 o'clock till 5 o'clock. You can have parenting then. So he can, as well as, does he have Wednesdays?
Yeah, those have been going.
As well as Wednesdays also.
So rather than alternate Saturdays, every Saturday.
Yeah, I'm going to have it. He's not going to have any overnights. And so normally he would have had Friday, Saturday overnights, and he's just we're going to have to figure it out. And according to, she'll be home every night. So we're going to have those hearings set up later on for parenting time.
Okay. Thank you, Your Honor.
All right, just a second. Mr. Hexel, anything further?
Is the order of the court effective today?
Well, it won't be till tomorrow. they should start this tomorrow. It's gonna be every Saturday and Wednesday. The hours are as I have stated, 10 o'clock till, what did I say? 5. He'll have that. He'll be able to maintain a relationship with his child. She won't have to spend the nights. She won't, whatever. And counsel, the two of you need to talk about setting up some type of counseling for the child and the father and that kind of stuff. Reach some kind of an agreement or something on that. Mr. Boyer, you need to be open to that. Go in and it can't hurt. So go into some kind of counseling with your daughter. The parties can set up an appropriate time. I mean, if it's reunification sort of stuff, he's going to have the primary say in who he wants. But it's, we've got to fit it in with her schedule and that kind of stuff. Summer's fine, but before you know it, we'll be back in school and you're going to have to set up something. I know that he doesn't live real close. I think he lives in Portland. And so, he may have to come into Grand Rapids for it because I don't necessarily want her driving to Portland for a 1-hour counseling session and then coming back. All right. So, Mr. Hexel, you and Mr. Browning need to work together to set up an appropriate counselor for Mr. Boyer to start whatever you want to call it, reunification. I'm not ununifying him right now, but you know what you both practice enough of this to know. Okay.
Yes, Your Honor.
So I will, we can put in the order also that the parties shall cooperate in setting up a counselor for Mr. Boyer and Hazel. All right.
One quick point of clarification, Your Honor. Are Wednesdays as previously exercised?
Pardon me?
Are Wednesdays as previously exercised?
Yeah. All right. And I mean, I'm trying to take into account Hazel. I'm trying to take into account both parents and all this kind of stuff. We gotta find some kind of solution. She's only 12. All right. And this is not really healthy for her, no matter what's going on. No one is to talk about this case. And I'll tell you, Mr. Boyer, if I do get word, if I get some kind of something that says you are discussing this case further, I will suspend your parenting time. All right. I'm not saying you did or didn't, but if I get some proof that you are, I will suspend your parenting time. All right. Anything else?
Nothing further, Your Honor.
Mr. Browning, you'll be responsible to draft the order, but draft it as soon as you can and get it to Mr. Hexel for his approval. All right. So we won't go through this again. All right. Thank you both very much. We're adjourned.
Perfect. Thank
Let's
you.
see how that, thank you. Here in the matter of Mitz v. Wiersma, both parties are present via Zoom. Mr. Hexel is representing Mr. Mitz. This is hold on, let me find the case. We were here 2 weeks ago regarding this matter. There was a question of whether or not Miss Mitz had sufficient notice, so we just set it up for this time. This is father's request for custody. I did receive I received some real concerning statements basically from the school that Ira goes to. Very concerning statements about mental health of mother. She denies she has a mental health problem or whatnot. Ma'am, I received many letters of people saying what a great person you are. It does appear that a lot of them were from like 2020 when I think you were headed for possibly jail or prison, and they were there to say, don't send you to jail or prison. They're 4 years old.
I was let out on a PR bond.
What?
I was let out on a PR bond.
I understand, but I'm saying your letters are 4 years old. Many.
Yes, they entered those as well to.
I understand. I'm just telling you they're 4 years old and not particularly relevant when they're 4 years old, but I've gone through them all. I understand, Mr. Hexel, we kind of talked about this last time, that there is apparently Vidvarka. Ma'am, you said you didn't have notice. Is there anything else you want to add briefly on your defense?
I would just like my kid back. I had a CPTSD night terror. It's over. I'm not suicidal. I'm still here. I'm still his mom, and I would like to resume that position.
I understand, and this really is not removing your child. This is a thing of a request for a change of custody. At this point, all I have to find is Vadvarka, which means proper cause or change of circumstance to have an evidentiary hearing on custody. I'm not changing custody or anything today, but there's clearly sufficient evidence as it relates to proper cause or change of circumstance, both the mental health issue that was, I mean, pointed out by the school. This is not that Mr. Mitz is saying, you know, these problems. The school was very concerned and had proper
I had
communication.
a nightmare about them taking him away, and they did just that. So it did not help me in any way.
I'm just going on what, all I'm doing is setting an evidentiary hearing. I believe there's proper cause or change of circumstance, set an evidentiary hearing regarding custody. It will be set up by my clerk. You'll get notices of it. There will be things that have to be followed. Miss Wiersma, without an attorney, you're going to be at a disadvantage because the hearing is going to be a formal hearing. Rules of evidence apply. There'll be things that you have to meet. They will come out in the scheduling order. Trial briefs, exchange of witnesses, and all this kind of stuff. So I'm just giving you fair warning, but I am going to set up an evidentiary hearing regarding custody. There is proper cause or change of circumstance, Mr. Hexel. Those proper cause and change of circumstances will also have to be met by evidence because I don't. Right now, I'm finding that there probably is, but you understand that. Evidence will have to be shown to show that there is proper cause or change of circumstance at the custody hearing. I'm not going to bifurcate it or anything like that. We're just going to proceed with it. But you understand, I know you do because you do this all the time. So
I do, Your Honor. I would request that we maybe refer this to the front of the court first so that they could flush some of this out.
my problem with it is it's going to add another 3 or 4 months to this process because it's almost guaranteed that at the end of it, unless that somebody's going to object to it. But if you want to do that, do you want to refer it to the friend of the court, ma'am? They'll get a chance to talk to you and to Mr. Mitz and to whoever they want. What?
I already said no to that to the lawyer. The FOC doesn't look at court documents. I'm not okay with that.
They do certainly look at court documents, so it's obvious that you don't know what you're talking about on that because they look at all kinds of stuff. Ma'am, I'm talking, you don't talk when I talk. I'll give you your chance. They do look at documents. They look at all kinds of things. They look at documents that you submit also. But see, Mr. Hexel, unless it comes back in her favor, she's going to deny it anyhow. So let's just set up an evidentiary hearing.
Okay, Your Honor.
Good luck, everybody. We'll set it up. We'll get Mr. Hexel, my clerk will be in touch with you. Ms. Wiersma, is there any time you're specifically not going to be around in the next 3 or 4 months?
I don't know what that's supposed to mean.
I mean, are you going to Alaska for a vacation in August or something?
Your Honor, I'm disabled. I can't afford a vacation.
All right, that's all. It's a courtesy question to you. You don't have to argue. It's just so we don't set something where you have something planned. Okay, you have nothing planned. We'll get in touch with you, Mr. Hexel, also and find your schedule, and we'll take it from there. Thank you all very much. We're adjourned.
Thank you, Your Honor.
No thanks. Makes no fucking sense. Give me to the judge. Where is Judge Hillary? Where is Judge Hillary?
That'll be a pleasant hearing.
Good morning, Your Honor.
Good morning. Can't believe you realize you're like one of the first on this time. Last time I think you were on at like 1:30 or 12:30 or something like that. You got on early today, Mr. Den Heuvel. Mr. Leader is connected. This is a matter of Bantland versus Leader. Both parties are present via Zoom. Miss Bantland has Mr. Howard Den Heuvel here representing her. This is a request to enter default judgment of custody. The original complaint asked for temporary and permanent custody. Mr. Leader never answered that, was ultimately defaulted. Obviously knows about this hearing. Mr. Den Heuvel, you did send him a copy of the proposed default.
Yes, Your Honor.
So, Mr. Leader, what's your response? I don't know why I wouldn't enter this. Hello.
Maybe switches to audio only and he can hear better.
Man,
I just understand the letter.
I can't hear you. Maybe take off your video or go someplace where you got a better connection. Well, now you're muted. That helps. You have a better connection inside? Can you hear me? Mr. Leader?
Did the court get copies for signature to send back?
What are you anticipating my ruling?
No, just asking if everything's in order.
I think we have an envelope and we have copies and everything.
Okay, good, excellent. We have some new staff on board, so we're kind of working through it, so.
All right. You've been doing this quite a long time.
Hello?
32 years.
Hello, can you hear me?
Yes, I can hear you. Can you hear me?
All right, Mr. Leader, what is your response to their request to enter this default judgment of custody?
And that would entail like we keep doing the same things that we've been doing, like the 2 days that I get to see him and everything.
Well, the default judgment of custody is what it is. You have been defaulted. You have an objection to me entering this? And if so, what
exactly does that mean?
I'm not here to teach law school. I'm sorry. Okay. It means that I'm going to enter this judgment because you never answered. They have sent an order through and you aren't making any objections to it, at least no well-founded objections to it. And so as a result, you got a copy of it. You haven't filed any objections, haven't stated any. So I think it's appropriate that I enter this default judgment of custody. It is what it is. You've got a copy of it. It says what it says. And if that's
Okay.
that's the agreement that you will be bound by, as will Miss Van Land also.
I understand.
So Mr. Den Heuvel, I'll grant your request. We'll sign the order and send it copies to you. I know you'll send an appropriate copy to Mr. Leader also.
Thank you, Your Honor.
Thank you all very much. Take care. Have a good weekend.
You too.
The defendant's not here now? He was? It's his motion. He was just on, and we just went to bring him in, and now he's gone.
Not a problem, Your Honor. I can wait. Yes.
It's a problem for me. Because you probably just have this one with me today, and I've got a lot.
Yes, I do have a 10 o'clock and 11, and
All right.
So I'll wait in the waiting room.
Maybe everybody can just mute for a minute. And we'll see if we can get them back. In the meantime, we'll take one. Ma'am, can you just put yourself on mute for a minute? Stay on the screen, and we'll see if we can get them right back while we do one in between.
Vamos a ver si lo podemos tener de regreso. Si gusta poner su botón en mudo, por favor. Y ahorita vamos a llamar otro caso. ¿Está bien?
She muted. Thank you. Can you hear me?
Yes.
All right. This is the case of Gates versus Gates. Both parties are present. On Zoom, this is father's objection to a friend of the court report and recommendation. I don't know what the recommendation was, but father doesn't like it because he says it's nowhere near 50-50, which isn't really an objection. But if you object to the entry of an order based on what they said, ma'am, I really can't do anything probably other than have an evidentiary hearing. They did apparently send out a recommendation back in looks like May. Did you get that recommendation, ma'am?
Yes, I did.
All right. Mr. Gates, I know you live, don't you live in Marshall?
Yeah, yes, sir.
And where does the child go to school?
He does go to school in Granville with his mother.
All right. Well, you can object to the report and recommendation. I'll tell you right now, it's unlikely you're going to get 50-50 because the child goes to school up here. And I'm not going to do it. So
my biggest thing, sir, was just to try and get more time than what's being offered, because currently I see him every single weekend and I have for about a year now. So the recommendation is actually taking away almost half the time that I already have time with him. So it's not doing anything. I mean, it's just simply taking away half of what I already have.
I understand. It's a fact of life. You live far away.
Right.
And you're not gonna get as much time as you used to get, apparently, or the recommendation. We'll see what it says. We'll set up an evidentiary hearing, send you notice. It'll be in person. Both of you have to appear, and we'll see what, I suggest you get attorneys because it's a formal hearing and we're not, there's gonna be rules of evidence and everything are gonna apply. So, ma'am, I can't enter the order if he objects to it. We'll have a hearing on it. All right?
Okay.
Thank you. We'll send notice to both of you.
Thank you.
Thank you.
Thank you.
Severa versus Nickens, set for a hearing today at 8:30. Apparently the mother is here. And she objects to the front of the court report and recommendation. Ma'am, how did you serve this on Mr. Nickens?
I served through mail. I mailed it to him,
When?
the same day, Friday.
Last Friday?
Or was it Thursday that I did it?
Not sufficient notice, can't hear it. You said in here you handed it to him on the 7th, but you didn't. Okay, well, that's what you wrote in here. Okay, that's what it says. Checked box. It says hand delivered as directed 6/7. Okay, and you say you mailed it to him on 6/7. You gotta mail it to him at least the Wednesday before that. It has to be Wednesday, not the Friday. So you have to renotice it. Like I simply can't because he's not here. All right, if he was here, I'd do something, but because he's not here, he didn't have sufficient notice. So it'll be up to you to renotice it properly. All right. Sorry, it's just something I gotta do. All right. Thank you. I mean, the reality is we're gonna have to set up an evidentiary hearing on this matter, but you gotta get in front of me with proper notice first. All right. And because I understand you don't have to communicate with him. You just have to mail it to an address that he's at. All right. And like I say, it's going to be really simple because quite frankly, all I can do is set up an evidentiary hearing. But if you don't get it in front of me, I can't set up an evidentiary hearing. Okay.
Because it says there that I asked for a stamp and an envelope.
I don't know what.
The legal assistants must have accidentally checked that.
That's fine. I mean, if you had handed it to him last Friday, it was appropriate service.
Right.
Okay. But because you didn't hand it to him last Friday, you had to do it the Wednesday before. You had to mail it to him. Okay. So you need to make sure you mail it to him before this next Wednesday. Okay. This coming Wednesday. So that then you can notice it for the following, the 28th. Okay. That's what you need to do.
Do I do another motion then?
You don't need to do a motion. You just need to do what's called a renotice. You fill out the card, renotice, send him appropriate document that renotices it. You can go to the 5th floor and you can tell them you have to renotice it for that. Can they give you help?
Okay.
All right.
Sure.
All right. Sorry. Thank you. Still no Mr. Carvajal Gonzalez. You represent Miss Kachari?
I do, Your Honor.
Yeah, I don't have an appearance, but I'm certainly you filed one or will.
No, you don't. I literally found out about this hearing 2 days ago.
All right, well, you will file an appearance. This is a motion to enter default judgment of custody. I was not going to really enter one today only because I don't have a uniform child support order that says I do have one. Mr. Ramaker, by the way, is here in the courtroom. Ms. Kachari is on Zoom. Actually, I was going to have Mr. Ramaker go and fill out an appropriate UCSO and send it out and renotice it for 2 weeks from now. But you're here. You understand what I'm saying is you didn't do all the documents that are correct.
They just said print out the thing because I'm not asking for child support.
Well, even then, I mean, there is child support that is supposed to be at $35 per month. Now, you're not asking for any, but part of the problem is when you put in here, child support, child care, medical insurance, support expenses are provided for in a uniform child support order. Okay, that's the box you check. Okay, and then one doesn't appear. It's not a complete document. However, Mr. Sherlin, what's your take on all this?
Your Honor, I think there's a major structural problems with this. First of all, I have no idea. From what I was able to learn from the Register of Actions, I have no idea why there would even be an order for alternate service. I have no idea what attempts were made at service. I mean, my client's not hard to find, Your Honor.
I think there's pictures even in here, maybe.
Was it a process server that did this, or was
There's
it?
Jerry Gross, a process server, all attachments delivering to.
Yes.
That was back on March 20. I mean, there's plenty of stuff in here about attempts at service.
Okay, do we even know if we have the right address?
I don't know.
I don't know either. I haven't seen the, my.
Does she live in Greenville? Ma'am? Unmute yourself for a minute.
Mute. Hello?
Hello, do you live in Greenville?
I do.
I'm not gonna give your whole address because we're on YouTube, but do you live at 1187?
I do.
Well,
And 11877.
then there, Mr. Sherlin, that's where, first class mail was sent to. I mean, there's all kinds of stuff in here about service.
Well,
There's something that's even, I got a picture here of it being attached to her door back on February 7 at 4:30.
well, here's the problem. In addition to the procedural problems, Your Honor, this would actually change a custodial environment. So the children don't live with the plaintiff, and they have never lived with the plaintiff.
So what you're saying then is all this kind of stuff, but your client never answered. She's defaulted. You know, she's going to be limited in the information that she's going to be able to put in.
Well, I'm going to need to file a motion to set this aside, Your Honor.
I know.
Right.
And I don't know that, I mean, most of those go to Judge Hillary and rarely are they set aside. You know that because you've practiced here for 100 years.
I understand. Your Honor, I haven't even seen these documents. My client only knew about this hearing because she got a text from the court system 2 days ago. The documents that were served on her showed up yesterday.
Well, you can take whatever steps you want, but it's pretty clear that attempts were made to serve her, and there are attempts through a process server, not through Mr. Ramaker. All right.
Okay.
And she didn't answer. All right. So
I've never received anything.
we'll set this, sir. I'm not going to enter it right now. You'll have Mr. Sherlin, you'll have 2 weeks to get a motion in there to set aside the default. Otherwise, we're going to enter this, okay? Unless she do something.
I still think that there has to be a best interest finding regardless of the default.
I can question Mr. Ramaker, but I'm not going to do it today.
No, I don't want to do it today.
I think I'm giving you 2 weeks to get a motion in here to set aside the default.
Right. But even if the default isn't set aside, I don't think this can be, I don't think my case law can be entered on a Friday morning.
We'll figure that out.
Okay.
All right.
All right.
Ramaker, you should be getting, and I'm not going to give your address out, okay? But is it 725? Oh, excuse me, I got the wrong. Okay. I got the other file, the person we're waiting for. Is it 4900? Yes. All right. You have his address on the documents.
Okay.
All right. Send it to him. We'll set it up for probably 2 weeks from now. You'll be here on what's called a motion to set aside. You'll be able to argue that. Whatever. It may be in front of Judge Hillary or myself. I don't know. All right, Mr. Sherlin.
Thank you, Your Honor.
Thank you.
I have one more with you this morning too. So
And you're going to be last on that one because you're causing a problem for me.
all right. Thank you.
Just kidding. We'll adjourn this and we'll see you in probably 2 weeks. All right.
Okay.
Thank you.
Thank you so much.
Thank you.
You can do Scott Sherlin's case coming up here. I hope he didn't take me seriously that he was going to be last. I mean, he can be, but I think he's with another attorney. Sierra, good morning.
Good morning, Your Honor.
Miss Thomas, can you hear me?
Yes, good morning. Can you hear me okay?
Good morning. Yes, I can. Mr. Kramer is connecting. All right. All right. Miss Thomas, you're now video. I don't have you video, sir, but you do have your attorney here. This is the man, Kramer v. Kramer. All right. I can see everybody. Everybody's on Zoom. Miss Sierra represents Mr. Kramer. This is a motion by the mother for change of domicile for Andrew to go to Canton schools. He lives here and has been going there, and she wants to change his domicile to there. Miss Sierra, I read your response. I understand your response. Ma'am, is there anything you want to add? I mean, I can't change his domicile, and it certainly won't be changed by July 1, because I can't have anything but a hearing. We've gone through a hearing with you before. You know what you got to do. You lost last time. But if you really want to have a hearing, you can have a hearing on change of domicile for Andrew.
Respectfully understood.
Pardon me?
I said respectfully understood.
Right. I mean, and I will tell you, I didn't read Andrew's letter because it's not appropriate that a 14-year-old sends in a letter, because I have no idea under what circumstance he writes such a letter. Yeah, you'll tell me he did it all on his own and all this kind of stuff, and I have no idea of if you helped him at all. It's a pretty I don't know what to say. No spelling errors and everything in it. But quite frankly, I don't read letters from kids on motions because I have no idea what situation it's written under. All right. So, Ms. Sierra, I guess I know your request would be to dismiss this matter, but you also know I don't really have a choice. I got to have an evidentiary hearing, a Lombardo hearing, to see if it's appropriate. Ma'am, it's going to be your burden of proof.
Understood.
Anything
Your
else?
Honor,
But
Your Honor, if I may, I mean, we had a 3-day evidentiary hearing on this already, and really nothing has changed, except it looks like Ms. Thomas has is trying a new way to get her way. I understand that an evidentiary hearing is on the horizon, but I would request that attorney fees be reserved because, again, we are litigating the same issues.
I don't care if you reserve attorney's fees, because I mean, as long if she has something legitimate, even if it doesn't result in her getting that, it's unlikely that I'll require it. I understand what you're saying. I sat through the 3-day hearing also. Okay. I understand what's going on. And if there is nothing that's changed, then ma'am, I might not be as generous, just coming back on the same stuff, but I don't know if it's the same stuff, and I won't know until I have an evidentiary hearing. So we'll set up a Lombardo hearing. Ma'am, I don't know when it'll be, but I guarantee it won't be before July 1, which is when you want him to change. Nothing changes in the order. We'll get to it. And if it's a 3-day hearing again, it's very likely that it won't be completed before school starts, but let's see what happens.
Your Honor, may I request that the evidentiary hearing be scheduled at a time in which will allow for discovery to be sent?
Well, I mean, by definition, I can tell you it's not going to occur before July 1. It's going to occur sometime. Most of our hearings are already way into September. We might try to get this earlier than that. But you'll be allowed discovery and whatever's appropriate. I'm going to urge you to get on with the discovery right away. So
yes.
I mean, I don't want you delaying trial because of it, but you can start with your discovery Monday.
Thank you, Your Honor. I will do
Right.
so. I will draft the order.
All right. Thank you very much. We will send out the order of when it is set for, but you should send out an order that reserves attorney's fees, because I'm not going to do that. Okay.
Thank you, Your Honor.
Good luck, everybody. Thank you. Take care.
Thank you. Bye-bye.
Thank you.
One more case, and then we're going to do Mr. Romero regardless.
Right.
Heyboer versus Church. All parties are present on Zoom. Mr. Heyboer, Mr. Church, and Nancy Ballast, who is representing Mr. Heyboer. This is mother's motion to set aside an ex parte, which I think we have already heard that in the past, and have set up appropriate, what I consider to be appropriate parenting time as a result of that. I'm not going to change that. Miss Church, we've already gone through that. What is something new to set aside the ex parte?
The CPS case has been closed. The police report found no evidence of abuse. CPS found no evidence of abuse. And as soon as I entered that motion again, now we're going for, he wants full custody again. He's done this 3 different times with accusations of abuse. As soon as they're found unfounded, he files motions for full custody.
Well, I'm sure he did. If there were allegations of abuse, I don't have anything from CPS police reports or anything like that. There are school records that I don't think that are particularly great while in your custody. He's asked for a custody hearing. And all I got to do to have a hearing is find Vidvarka, which is proper cause or change of circumstance. Miss Ballast, what do you submit as proper cause and change of circumstance for the custody hearing?
Good morning, Your Honor. We submitted that the older child has been flourishing while in father's care. There's no longer behavior concerns. In the past, there were daily behavior concerns for the older child. I provided the teacher's progress notes for about 3 weeks worth of school attendance, and he's doing very well. Also that the older child's doctor decided to remove him from medication as a result of this improved behavior while in my client's care.
Is your client just seeking custody of Hunter?
Both children.
All right, well, that's.
And also, she wrote a response to our motion for this change of custody, saying that she was not able to attend a school event or that my client did things unilaterally about change in medication. None of that is accurate. She was not barred from attending any school events. She voluntarily showed up in May at the child's school to talk with them about the pending custody hearings. So I'm sure she's aware that she was allowed at school. The doctor did confirm with both of them that it was safe to take the child off medication. And then she goes and sort of says, my client's not available for parenting time or custody, saying that he's still a field technician, and that is not accurate as well.
I understand you're arguing against what she says, but I'm just asking you what you see as proper cause or change of circumstance.
Definitely the homeschool and community record of the children and the current environment of the children is in favor of my client having a custody evaluation done.
All right. Ma'am, I think the request isn't to change custody today. The request is for a custody hearing. And there is proper cause regarding school record for the child. He's not flourishing in school. I'm concerned about it. I'm not making any determination now whose problem, whose fault, whatever. All right. But that is proper cause. I'm not certain that the other factor that says the length of time the child has lived in a satisfactory environment and the desirability of maintaining it is also a question. There are things going on at your house that I'm not real. I don't know whether or not they found.
That happened.
What?
They haven't even happened.
Well, I don't know. How do I know that? Tell me how I know that.
I don't know how to prove that because it seems like anything that he says to the court is taken as truth, and I
It's
can't.
not taken as truth. I know that there are things that obviously there was enough that CPS and the police investigated. All right. I'm sitting here and I don't take his word and I don't take your word for it. All right. That's bottom line is I'm just setting up an evidentiary hearing because I'm going to try and get to the bottom of it. I think things at school, certainly the situation, it's appropriate to reevaluate it. It may turn out that you win 100%. That's what we have hearings for, because I can't make the decision on a Friday morning. All right. I don't know if it's correct or not. You can get an attorney. I think you've had an attorney in the past. Was it Mr. Reams?
I can't afford an attorney.
I don't know what to tell you. Then you'll have to represent yourself. It would not be wise, but you can bring in evidence just as Mr. Heyboer can bring in evidence, and I'll listen to it, and it will be according to the rules of evidence and whatnot. And you'll testify and you'll provide documentation or whatever, and I'll make a ruling on it. So I am going to set up an evidentiary hearing regarding custody because at least preliminarily there is sufficient showing for that. Alice will contact you to set up a hearing as quick as we can. And until then, we'll continue the current order. All right.
I'll prepare today's order. Thank you.
All right, ma'am, we'll send out notice to you and hope that you can obtain an attorney. I'm not changing custody. I'm not doing anything today of a permanent nature. So good luck, everybody. Thank you.
Thank you.
Mr. Romero, are you still there? I know you got a 10 o'clock, so we're going to get you to it.
Yes, Your Honor. Thank you.
Yes, I'm still here.
Gato Rosales versus Carbajal Gonzalez. This is father's objection to child support from a uniform child support order of April 23, 2020. And apparently The defendant logged on for a minute and then logged off. We called this case about a half hour ago. And just before that, the defendant logged off and is not logged back in. We've had an interpreter, Mr. Romero, and the plaintiff present the whole time. This is the father's objection to friend of the court, to the child support order that he makes for a couple of reasons. The objection basically says he pays bills. He paid for children's swim class and apparently a tablet for the kids. And he has another child to support. The court has reviewed the UCSO, the Uniform Child Support Order, and finds that he was given credit for having another child. In the calculation, I believe the mother also has another child. Credit was given for both. As far as his other objections saying he has bills to pay and pays for swim classes and what, they are meaningless. He has not objected to anything of substance at this point. So I'm going to deny his motion.
O sea que negaría su moción.
Miss Delgado Rosales, is there anything you wish to say briefly?
Actually, do I have to file a motion to add days to his, because he hasn't been picking up my kids like he's supposed to?
That's not before me. You got to figure out what to do.
Okay, sounds good.
Thank you, everybody. Thank you, Mr. Romero.
Thank you very much.
Have a good
great
day.
weekend.
Have a good weekend. You hear me?
Take care.
Hello?
Hello? Can you hear me? Hello?
It's all the way up.
Can you hear me? Back in the waiting room. I'm going so fast you can't even hardly keep up. Mr. Smith, can you hear me?
Yes.
You, how did you get this motion to, Ms. Couch?
It was hand delivered.
When?
The day I put in for the motion.
Okay, so it was hand delivered by you or what?
Yes.
You handed it to her at like an exchange or something?
Yes.
And that was back in May, it looks like. Is that correct?
Yes.
All right, this is the matter of Couch v. Smith. This is a date and time set for a motion. A couple of them filed by the father, an objection by Mr. Smith to the friend of the court, report and recommendation and a request for custody. I'm assuming, look here for a moment. The matter was just referred to the friend of the court back in January for parenting time. The fees were waived. By the way, just for the record, the mother plaintiff has not been on, was apparently given appropriate notice, has not ever appeared, was set for 8:30, is that correct?
I'm here.
Oh, all right. No, you're on a different case. You're on a different case.
Oh, okay.
So just mute yourself for a minute and we'll get to you.
Okay.
Right, and it has not appeared. As I say, father has made a motion. The bottom line is that it appears that the child has been placed with the father through the abuse and neglect system. Isn't that correct, sir?
Yes.
He is a non-respondent in an NA case that is pending in this court. As a result, any objection, of course, an objection that you make to the friend of the court recommendations was probably processed primarily prior to the child being placed with you. When was the child placed with you through the abuse and neglect case?
April 25th.
All right. And friend of the court probably didn't know about it even. I don't know, but it doesn't really matter. There's clearly proper cause or change of circumstance to have an evidentiary hearing regarding this matter as far as custody, parenting time, even child support, under the circumstance that the mother has been made a respondent through the abuse and neglect court, and father is not, and the child is placed there. Sir, what we'll have to do is we will have to set up an evidentiary hearing because I can't just do anything here today. All right, I'm not allowed to. But
Okay.
But the child is placed with you through the abuse and neglect case. I couldn't change placement now anyhow because that case takes precedent. But I'm understanding that you are hoping to get custody and then, I don't know, maybe even get the NA case dismissed or something. I don't know. All right.
Yeah, yeah.
And that's a request that's pretty normal in those sort of things. We'll get you in as quick as we can for an evidentiary hearing. Miss Coletti represents you, is that correct?
Yes.
All right. You should talk to her and maybe even have her contact me. I might see if she can help you out at that abuse and neglect at my custody hearing so we can get through that. All right. I know what's going on and in that matter. So we will set up something quickly and because you really should have an attorney. It's much better for you if you have it to obtain custody. But I can't change it today. I could gather from what you said, Ms. Coletti said you should file this, which is great and all that kind of stuff. But I have to have a quick hearing to make sure that I would change custody to you. All right.
Okay.
So you're going to get notice of an evidentiary hearing that will be sent to you at, I'm not going to read your whole address because we're on YouTube, but it's 1316. Is that where you live?
Yes, correct.
All right. We'll get that out to you. Contact Miss Coletti and tell her where we are with this and that see if she could even contact me on this matter. Okay.
Okay.
Thank you very much. Good luck. Have a good day, sir.
You too. Thank you.
Thank you. Ms. Bennett, are you there?
Yep, I'm here.
All right. This is the case. The plaintiff is present. The defendant is not. Did you serve him? He's apparently out at the Kent County Jail.
Nope, I served him at the jail. I sent the mail over to the jail.
All right. You sent it out there. It looks like 3 or 4 weeks ago.
Yep.
All right. I know this is your request to find that the child is born out of wedlock. The problem is just up front. You sent me a report from Walgreens. All right. That says he's not the father, but in the statement from the DNA test report, it says the laboratory is not responsible for wrongful collection. It also says cases are personal knowledge only and cannot be used as legal evidence of parentage. That's what it says right in the Walgreens. Okay?
Absolutely. Absolutely. When I went to the Kent County Jail to ask them how to get him tested, like through a lab, through you guys or, something from them, the Kent County Jail said that was all they would accept. And they had me run straight to Walgreens right down the street from the jail. And I got the cadet's name that swabbed him because that's all they would do. They said they are not responsible to take him out to a lab or.
I understand.
And so I talked to several sergeants and lieutenants, and that's all they would accept. So I had took the cadet's name down, which was Cadet Newman, who swabbed him. And we closed it right there with the cadet because that's all the jail would let me do. Yeah, I went and I talked to several lieutenants, sergeants. I gave them the court order from the original court order I had from you to get them DNA tested, and they said that's all they would accept. And they had a cadet go up and swab him, and then the cadet sealed it and gave it back to me with his signature on it.
With a cadet's signature on it?
Well, no, with Joshua Bennett's signature on it. But the cadet, I did take the cadet's name down, and it was Cadet Newman who swabbed him.
I'm just afraid that, I'm just afraid if I say the child is born out of wedlock, boy, sure. Do you know if Joshua even thinks that this child is his?
Nope. Well, I guess you probably wouldn't remember because you have so many cases, but back when we first started this, he went on record and told you he knew for 100% fact this child was not his. Because you had asked him on record one time, are you sure this baby's not yours? And he said yes. And then you said we still had to get a DNA test because it was the law.
All right. Do you know who the father is?
Yes, I do.
Can you tell me his name?
His name is Joshua Gorey.
You pick Joshua's? Is that what?
It seems that way, don't it?
All right. Is he there with you?
No, he's not. He's currently incarcerated.
He's also incarcerated?
Yes. He's an MDOC though.
Just some friendly advice. Maybe Joshua's who are going to jail are not in your best interest, but
you are correct.
But that's none of my business really, but it doesn't seem. Are you gonna do anything to make him the father?
Well, yeah, we had to wait till this was all said and done because she don't even have a birth certificate because we didn't, that was why we did this, the whole court hearing. Well, I mean, obviously I want to be divorced too, but we can't even get her a birth certificate till this is all said and done.
So you're now gonna get an affidavit of parentage or something signed by both of you, this is the child? All right, it's against my better judgment, but I'm gonna put you under oath for a second. Please raise your right hand, okay? You sound, your other right hand. Okay. You solemnly swear or affirm testimony given in this case to be the truth, whole truth, and nothing but the truth.
Yes, Your Honor.
Thank you. Everything you've told me here in this motion is true, is that correct?
Yes, Your Honor.
That you did have a cadet from the Kent County Jail signify to you at least that he swabbed Mr. Bennett and brought you that. It was sealed and you took it to Walgreens for a test.
Yes, Your Honor.
And nothing else interfered in between or whatever.
No, Your Honor.
And your testimony is that the father of Jalia?
Yeah.
Is actually Joshua, what's his name?
Goring.
Goring. All right. And that you are going to see to it that he is made the legal father.
Yes, Your Honor.
All right. And it's your sworn testimony that there is no chance that Joshua Bennett is the father.
Yes, Your Honor.
All right. I'll sign the order, finding that the child was born out of wedlock. Was that the only child involved in this case?
There's three other children, but I had tried to speak to you about this last time. The three other children, are with my mother and have been for a very long time. Like my mother has adopted two of the children and then she has guardianship of the oldest one. And I was actually told by legal aid to dispute this with you a while back, just because they've been with her for a long time, and to see if we can move forward with the divorce without minor children.
But I can't move forward with divorce without minor children. If the other children are legally adopted and you do not have legal rights to them, that's one thing. Okay.
Yep, that is true with two of the children.
All right, but you still have a third one. And it's not like the child has been legally adopted. So it still remains a DM case right now, because in theory, you could go get that child back by terminating the guardianship right away. All right. You're still the legal parent. All right. So I will sign an order that Jalia is not a part of this case, but you're going to have to deal with the other. It just is what it is. You're going to have to do 6 months.
And then my next question is usually when you get divorced with minor children, it's 6 months out. We're at our 6 months.
Well, if you've done go to the legal assistance center down here and see what they can do to help you get it done. I can't give you advice. I've already given you more advice than I'm supposed to. All right.
No, absolutely. My question is just like, where do I go now? Like, where does the divorce?
Go to the legal assistance center here on the 5th floor and see if they can give you some help. Or call an attorney. They could help you, but
I'm just where do I go? Not where do I go, but where does this leave my divorce at? Like I can't move forward with my divorce, or
yeah, you can move forward with your divorce. I don't know whatever. I'm only here to find that that child is born out of wedlock. Okay, that's the only thing I'm doing here today.
Okay.
And as far as the rest, I mean, you can continue on with your divorce.
Oh, okay, great. That was my only question, is I just want to continue being divorced.
All right. I'll issue that order that the child's born out of wedlock and you can continue on with your divorce in whatever direction it should go. All right.
All right. Thank you.
Look, thank you.
Thank you.
Okay. There's an order in there. All right. This is the matter of Samuel. Is it Antoine?
Yes.
How I pronounce your name?
Yes, that's right.
All right. Samuel Antoine versus Tracy Antoine. This is a motion filed by Mr. Antoine, the plaintiff in this case, to object to an ex parte order that has been in place here. Apparently, the Judge Hillary signed an ex parte order on 5/15 that the defendant is granted extended parenting time and shall bring an immediate motion before the court as this is a temporary order. Tracy Antoine, I don't think has filed any motion as far as I'm concerned. as far as I'm seeing. Has she? Have you gotten anything from her?
No, I haven't got anything from her. Even the papers I have the wrong address.
What did you do to get this to her so that she would show up here today?
I went downtown to the courthouse. That's how I find out something was filed. And then due to me being in the courthouse, I end up talking to one of the clerk. The address that she put on the paper is wrong. So I never received any paper from her. So it's just me taking me to call to just check to see what's going on. And that's how I find out there was something filed. But when I went down there and filed the motion, I end up having her address. I even put it in the mail and so she could get it.
When did you put it in the mail?
I did on, let's see what the date on that. It was the same day, actually, the same day I went downtown, which is.
Can you check and see if she had filed anything?
We filed the motion. We filed the objection.
Yeah, we filed the objection. She filed the motion, and then
you filed an objection. She filed a motion.
Yes.
We're just checking to see if she filed a motion.
Okay.
She filed an ex parte motion on 5/14, which was granted by the judge, but also in that said she must file an immediate motion before the court, as this is a temporary order.
Which I know nothing about. When I called
Did you
down
get
there,
anything from her besides the ex parte order, the ex parte motion?
Actually, I had to go downtown. That's when I got it. I never received anything in the mail.
Okay, but you got the order downtown here.
Yes.
But she has not filed another motion, is what you're saying.
No.
And you just filed this, and you're sure that you mailed this to her appropriately?
Yeah. Yes, I did.
All right. All right, Mr. Antoine has filed a motion to set aside the ex parte order, and most troubling to me is that it is a month since that order was entered. The court specifically said shall bring an immediate motion before the court, as this is a temporary order, and that was directed to the defendant. She would have gotten a copy of that and has not followed through on what has been told to her by the court.
So she should, because I put that in the mail.
I understand. I'm just saying she didn't follow the court order and file a motion. I have checked with my clerk. There's been nothing that she has filed since receiving this ex parte order, and she's had basically a month to file that and has not done so.
Yes.
As a result, in Mr. Antoine filing a motion to set aside the ex parte order, I don't have to go through much to set it aside, because she, quite frankly, like I say, has not followed the court order by immediately filing a motion so that this temporary order could be heard. I don't know what went on and all this kind of stuff. I had a chance to look at what she says, what father says, and whatnot. And so I guess the appropriate, and I've read his additional supplement and whatnot, although that would not have gotten to her, and I shouldn't necessarily have done that because he didn't fulfill the amount of time that was necessary. You sent that to her too?
Yes.
But you would have sent that to her on the 11th. We're on the 16th, and she may not have ever even got that. That's not sufficient notice, but you say there was notice, and that she did have that you mailed this motion to her on 5/23/24. She's not responded. She's not done anything. She's not followed the court order. Therefore, I'm going to set aside the ex parte order. Thank you. All right. I don't know what's going to happen from here, but I'm going to set it aside because she has not followed through on what is required. So that order is set aside, sir.
So what do I do next? Do I have to go down?
You should probably go to an attorney and figure out. I can't give you advice on what to do next.
Okay.
All right.
All right.
Thank you.
Thank you.
For failure to follow the court order. Hello, Cheryl, and everybody out there in YouTube land. Several weeks.
And
Carrie, Missy probably not. She's in Japan.
Amy Drummond is no longer in this
Mr. Sherlin, you left us just because I jokingly said you were gonna be last. We would have done you a little bit sooner, but, sorry. That was,
Oh, sorry about that. I had to check in with the mediation that's going on anyway.
okay, well, you were on early and I said, you know, you're causing problems, so we're gonna make it last. It wasn't really true.
I didn't take it that way.
But, all right, we're here, Puffer v. Puffer. Both parties are present via Zoom. Mr. Sherlin is present for Mr. Puffer. Ms. Grauman, who I had listed on this, apparently is not, Ms. Rodriguez. Well, Ms. Rodriguez, is Ms. Grauman no longer, your attorney in this matter? I couldn't hear you. Speak up.
Yes.
All right. This is, Mr. Sherlin's, request to enter an order from a last August settlement. He has provided an order to the court that seems to comport with.
Your Honor,
what?
that order has been entered, so it's only the second part of the motion that we're dealing with.
When did the order get entered?
Before, when we had it noticed 2 weeks ago, Ms. Grauman sent me the signed order and we sent it over to the court for entry. I don't know if it's completed yet, but it was.
You know, I can't enforce an order that isn't signed yet and stuff. I mean, you're asking me to enforce a court order. I'm not even sure. I'm not saying the stuff that you're saying in there is inappropriate, but you understand that, I mean, if you were to file a show cause on an order that's not entered yet, you're not going to get any.
That's not what I'm asking for, Your Honor. I'm asking for instruction from the court that the defendant shouldn't be talking to the children about the court case, period. And
period. You can enter an order today that says neither party is to discuss this court case with the children. Ma'am, if you do, it's not gonna go well for you. Leave the kids out of it. Same to you, Mr. Puffer. I'm not saying you do, but you have counsel who I'm sure is telling you do not discuss this. If you want to send through, Mr. Sherlin, an order that says neither party is to discuss this case or the court case or whatever, however, you know what I'm saying. I will sign it. Ms. Rodriguez, do you have any problem with that?
I don't, because the accusations are false, so it makes no difference to me, Your Honor.
All I'm doing is making sure nobody does it, and if I get proof that they do, it will not go good for the offender.
Absolutely.
And then, Your Honor, the last part of the motion is the defendant's significant other, Sean, keeps injecting himself into the phone parenting time conversations. And my client reports he's saying disparaging things about food that they eat for dinner, different things like that. It's the defendant's parenting time, not Sean's parenting time. We would ask that he not be part of the phone conversation.
That's just, I can't micromanage this, but ma'am, he's not part of this. This is between you and Mr. Puffer. This is your kids, Mr. Puffer's kids. I know that if he is a stepfather or whatever, I know that he is in their life, but this is between you and Mr. Puffer. You understand that, don't you?
Oh, absolutely.
All right. So,
Your Honor, may I?
What?
So if the children request to say hello to someone in my household, am I not allowed to allow that? Because I was just confused on that small detail.
Okay, again, I can't micromanage this, and every child that does everything everywhere it's time to be adult in this, all right? And your time is with your kids, all right? I don't know what he does or doesn't do. What Mr. Sherlin put in the pleadings would not be appropriate. And you should be able to tell that to your, whoever it is, boyfriend. Just stop it. Just leave it. This is between us. Yeah, the kids say, hey, can I say hello? Yeah, Sean, hello. End it, all right? Or, I mean, the kids aren't away that much that they can't just go home and they see him there. This is your time. I guess I could stop all telephone contact if that's what people would like. Is that what you'd like?
Of course not, Your Honor. It's just the facts are always misrepresented. That's my.
I'm not even saying they did or didn't happen. It's time for the two parties to be adult. You got to control whoever you're with. All right.
Of course.
Mr. Sherlin, I think I've given enough instruction that if something happens on that, I'm not going to say he can never be available per phone. I mean, yeah, if the kids do say, hey, can I say hello or something like that, or hey, I want to tell Sean something. That's not. I can't micromanage this, but darn it, if Mr. Rodriguez, if he starts becoming a part of this, you know what's gonna happen to you. This is you and Mr. Puffer and your kids. All right?
Right.
Mr. Sherlin, you can enter the prior order. I don't know how to enter an order that says he shall not interfere in, nobody's nobody's partner can interfere in the relationship between the parties. Is that what you're, or well, I mean, what do you actually want to draft?
Your Honor, I think that'd be fine. It's the parents' parenting time and the other.
And deal with it accordingly. Yeah, just come on. And but anything you put, it's mutual.
Yes. Yep.
Yes, ma'am.
That includes Bree as well, because she interjects and interrupts.
I just said it's mutual. I said anything he puts in there is mutual.
Okay, just making sure Mr. Sherlin understands that, because Bree also inserts.
I understand it, and I know Mr. Sherlin. See, the only thing I'm saying to you is because you don't have Mr. Sherlin or somebody representing you, who Mr. Sherlin will talk to Mr. Puffer, I'm sure, and tell him what he needs to do. All right, nobody's to interfere in this, so you may send over an order, Mr. Sherlin, 7-day, I'm sure. Ma'am, that means he's going to send it over. You have 7 days to object. You can't object because you don't like what I ruled, but you can object if it's not what I said I ordered. All right.
Absolutely.
And
Yep.
if not, then I'm just going to sign it and put it in. Let's get rid of this and start becoming adults. Good luck, everybody. Thank you, Mr. Sherlin. And I didn't mean you were going to be last. All right.
No, I understand.
Neighbors, take care. Have a good week. We have both parties present, and I think they can hear me. We also have Attorney Miss Walker and Mr. Reens present. Mr. Reens is here to represent Miss Neighbors. He is standing in for Miss Van Dyken. Miss Walker is representing Mr. Buxton. This is a motion to compel answers by the plaintiff. They are long overdue. Miss Walker, what can you tell me?
Yes, referee, we were having some complications with getting some of the documents. Those have all been sent to Ms. Van Dyke via FedEx as of yesterday. The attachments were too large, so I sent them to her also in separate emails. So she has all the documents that she's requested, as well as the admitted answers to the interrogatories.
Mr. Reens, can you confirm or deny that?
Your Honor, we received some emails, and by we, I mean Ms. Van Dyken, received some emails at 1:30 this morning, and it purported to respond to these interrogatories. A quick review of some of what was submitted is somewhat comical in that they've submitted credit card statements that they've redacted. And so you can't see whose credit card statement it is. I mean, they've redacted the account holder, and then they've redacted several charges from numerous statements. So from our perspective, there has not been in any sense meaningful compliance as of this date. But for our purposes this morning, Your Honor, I think this is quite easy, right? No objections were ever filed to any of these requests. So the easy and appropriate ruling this morning would simply be that there be full and complete answers to each and every interrogatory and request for production of documents within 7 days. And we would ask the court to reserve attorney's fees.
There's Ms. Walker. That's a reasonable solution. I don't look at the fact that Mr. Reens, Ms. Van Dyken might not like some of the answers. Oh, well, all I want is full and complete answers 7 days from today, the 21st. And if you say that's full and complete answers, I'll deal with it next. All right.
Yes. Can I comment on the response to the redacted documents that were submitted? That account is held with a joint account holder, and which I explained that in an email to Ms. Van Dyke, and that is why it was redacted with that party's information on there. So it does show Mr. Buxton's name on there. It shows the transactions under Mr. Buxton. Only thing that is blocked out or redacted is things that do not belong to Mr. Buxton, because it is a
I'm not
shared.
going to try that matter here, and I'm not going to find findings on it one way or another, because I don't know. All right.
Okay.
So all I'm doing is full and complete answers by next Friday. If you say they're all done, they're all done.
Yes, they are.
And that I'll reserve attorney's fees. That doesn't mean anything other than if they aren't appropriate and I find somewhere down the road they aren't, then I guess I can grant attorney's fees. But for here, that'll be the requirement. Mr. Reens, you can draft an order that full and complete compliance with to compel the answers, full and complete answers will be due by next Friday, and I'll reserve attorney's fees. That's it. There's not much really to this, all right?
Yes, thank you.
We will draft, Your Honor. Thank you.
Thank you. Everybody have a good weekend. Take care.
You too.
Can you hear me? Thank you. You can shake your head because you're on mute if you can hear me. All right. Miss Tiff, same to you, but you can't shake your head because I can't see you. So can you hear me? You have to unmute.
Can you hear me now?
I can. Can you turn on your camera, please?
I'm trying to find where that is. Okay.
All
Okay.
All right, this is the matter. Tiff. Both parties are present. Plaintiff, Mr. Tiff is represented by Ms. Canfield. Ms. Tiff is unrepresented. This is her motion. Essentially, two motions. First is to extend the discovery deadline to July 22. Now, I do have things in here, counsel, that seemed like at one point you guys were stipulating to it. Is that correct?
Yes, that is correct, Your Honor. We did have a settlement conference before Judge Hillary a couple days ago, and we at that point stipulated to the extension of the discovery for 45 days. So it would go beyond that. I believe the court will be issuing an order in that regard. So really,
Judge Hillary allowed extension for 45 days?
that is correct.
All right. Ma'am, that's a dead issue then, okay? The other issue that she said is limit access of Mr. Tiff to the marital home. And from what I understand, he hasn't been living there for quite some time. I understand, counsel, you say that he still has a lot of his stuff there and stuff like that, but he hasn't been living there for quite some time. Is that correct?
That is correct. And it's basically because of the situation between the two of them and the breakdown of the marriage.
Well, yeah, I mean, we don't often have people who are divorcing. I don't force them to live together.
Well,
Even though I
would
should,
very
maybe they'd get it
much,
worked out, but I can't think of a reason why I wouldn't just enter an order that says exclusive use and possession to Miss Tiff for now, with the understanding that, ma'am, this is all gonna come out in the wash anyhow. Is there anything, Miss Camfield, that you are specifically asking for out of that house right now that he needs? This is all gonna come to an end sooner or later anyhow, all right?
Correct. We have mediation scheduled, and I will be sending a proposal to Ms. Tiff that my client and I have discussed. So we'll get the negotiations underway. There are some things that he would like to have. He is going to send me a list for that. I would note that prior to the court hearing this matter, it even being motioned, Ms. Tiff decided to change the locks on the home of her own accord so that my client could not access his things without court order. So I do find that
All right.
disagreeable.
It doesn't, I mean, face it, I'm guessing these parties don't get along too much anymore because they're getting a divorce, okay?
That
So
is
these
correct.
sort of things happen. I'll just, counsel, I'm even gonna ask you to please draft this order that extends discovery for 45 days from whenever it was that you had that hearing. All right, that the judge said he will extend it 45 days, and she'll have exclusive use and possession of the marital home until further order of the court.
Regarding the expenses, Your Honor, I don't feel my client should have to be responsible for any expenses if he doesn't have access to the home.
That's not really before me. I mean, I can't deal with that. And clearly, if he has expenses that he shouldn't, that'll be part of mediation because he certainly can get credit for it if he's spending a lot of money and not able to live there or whatever. But that's all, Ms. Camfield.
Certainly.
I'm kind of preaching to the choir here. I know you know what I'm talking about.
Right. Indeed, Your Honor.
Ms. Tiff, you're gonna have to educate yourself if you're not gonna have an attorney on what's appropriate here, but you need to go to mediation. You need to mediate positively, okay?
Yep.
I'm aware of Ms. Camfield and she will, but you need to go in and be realistic. Have you chosen a mediator?
Yes, it's already scheduled, Your Honor.
Do you know who it is?
Oh, gosh, I can't.
I'm just getting nosy now. You probably have enough.
It's probably Mike D'Antona. That's typically who I prefer to utilize.
We haven't discussed that part yet, but in my settlement statement, I made sure that the judge knew that I was the one initiating that. Miss Camfield actually said she didn't think that would work. So this is the first time I'm hearing that she is open to that since
All right,
2 days ago.
I'm asking more questions than I need to know about for this
All
motion.
right.
I'm just hoping to try and get this thing done eventually, so.
Certainly.
Canfield, if you would, please draft that, ma'am, she'll send it to you through the 7-day rule, which means if it's not what I ordered, you can object to it. If it's not what you like, that doesn't matter. You're gonna get exclusive use and possession in 45 days, extended, discovery. Good luck, everybody.
Thank
Yes.
you. Referee Frederick, if I may my client have, with provision of a list and coordinating dates through me, one time to go to the house to get some additional personal effects before the completion of the divorce?
Yeah, I would do that, except I don't know what's gonna be on the list, and if he's going to say, I wanna take the kitchen sink and the refrigerator and stuff, I don't wanna set that up. That would be a perfect thing. You're not too far from mediation to mediate. I think, ma'am, if she comes back here sometime later and says, look, he's got his winter clothes there and it's closing in on winter, I'm gonna give it to him, all right?
Absolutely.
So just everybody be smart about this. His stuff is his stuff, and I don't care how much you guys don't like each other anymore. Get him his stuff and make appropriate arrangements for him. All right?
Of course.
But that's not part of this order, okay?
Okay.
You guys are just gonna do that. If you need to come back, you need to come back, but I don't think so. So exclusive use and 45 days and get along well enough to get this over with. All right. Good luck, everybody. Thank you very much.
Thank you. Have a good day.
You too.
Thank you.
Your name, please, ma'am?
Tracy, Antoine.
All right, you're logged in as Kim Downer.
I'm using her phone.
All right. Well, I've already had the hearing because we didn't know you were here.
Yeah, we've been sitting in the Zoom.
All right. Well, we didn't know you were there because you were listed as Kim Downer. All right.
Okay.
Did you, I mean, it usually tells you to log in and make sure you log in your name, but I'm going to tell you right now that I set aside the ex parte, and the reason was you never filed a motion as required by the judge. The judge said in the judge's order, it says defendant is granted extended parenting time and shall bring an immediate motion before the court as this is a temporary order. Okay. And that's what it says. And it's been a month and you never filed an order or you never filed a motion.
Okay, well, I have the motion here with me today.
Well, that doesn't help. You've had a month. I mean, why didn't, seriously, you've had a month and that's exactly what it says in there, shall bring an immediate motion. What am I supposed to do? You didn't follow the court order.
I wasn't able to file the motion right away. I had put in for the financial assistance thing and it denied it, but I had been laid off of work for 2.5 weeks and didn't have the $100 to send in for it.
But did you come in and ask that the fee be waived?
Yes, I did. I filed all the paperwork for it. That's why I have it today, because I just got back to work and got my check and was filing it today.
But what did they say when you asked to waive the fee?
They said that I couldn't get approved to waive the fee. I already filled out all the paperwork for it.
File a motion for in 2 weeks and we'll see what happens.
Okay.
All right. I set aside because you didn't follow the judge's order. You can file a motion in 2 weeks for, extended parenting time or something like that, and I'll hear it in 2 weeks. Until then, I'm sorry, but even if you'd said you've been laid off for 2.5 weeks, but before then you weren't laid off on the 15th of May, is what you're telling me.
No, that week was the first week that we had been off. That's why I filed for the to be able to get the fee waived.
All right, you better file a motion and we'll see what happens in 2 weeks.
Okay.
Good luck. Thank you.
Hello.
Hello, Miss Garber.
Hi, how are you?
Good. You are present, but Mr. Miller is not. This is Mr. Miller's motion for an objection to the friend of the court. This is case 7. This is Mr. Miller's objection to the friend of the court report and recommendation. It was sent out on 5/15/24 to the parties. He asked that the process not be terminated. Apparently there was for an evaluation. Did you get notice that the friend of the court evaluation was being set was not going to occur because people didn't provide stuff or what?
I'm sorry, Judge. I'm having a hard time with my volume on my phone, but I can hear you. No, I didn't get word of that. I participated in that evaluation and was present. And even talked a little bit to the evaluator after the fact. So I did not hear anything. And actually, I didn't even know that we had court today. So I do just want to shout out that you guys send out text messages and emails, because I would have had no idea unless you guys didn't do that. So thank you. I do appreciate that.
All right, well, it's his motion and I'm not going to grant it because he's not here.
Yeah, I don't, Judge, I'm having a really hard time with this, because if it was a priority in your life, you would make it a priority to be there. And this is the third time it's a no-show. And I'm just trying to wrap my head around the fact of like, what is your intentions at this point,
Is he still $18,000 behind in child support?
Yeah, I haven't seen an actual payment in quite some time. So.
All right, well, he's not logged in. What was this actually said?
He had a court date on, I think it was a week before we had court. I think it was March 13th on his rears. And I don't know, Judge, I never go to these things because it's not for me to be there, but he ended up paying like $20 and said he would pay an X amount by the end of the month and never did. So I don't know how he continues to get out of.
It'll happen sooner or later. Let me just, this is his objection to the friend of the court report and recommendation. However, he did not show up. It was noticed for 8:30. I'm taking it you've been on the line for quite a while.
Yep.
All right, you did show. I'm going to deny his motion for this, and we will continue, quite frankly, I'd probably enter the friend of the court report and recommendation. All right.
All right,
I'm
Judge.
going to deny his request regarding objection to the friend of the court report and recommendation for failure to show up. Good luck, all right?
Thank you so much. I appreciate it. Have a great day.
You too. Number nine. That's kind of sad.
I know, but at least I told you.
Number nine. Famous Beatles song to those of you out there. Off the White Album, I think. Number 9. Klein v. Klein. Parties are present via Zoom. This is father's motion for some parenting time. It wasn't very long ago that I remember I had a motion to allow mother and the children, there are two kids, 14 and 12, to move to Idaho. It was granted because it was clear that she had full legal custody according to a default judgment back in 2019, and that quite frankly there was no chance it was going to affect an established custodial environment because dad hadn't exercised much time with the kids. He's now asking for some parenting time because, ma'am, you're out in Idaho, and I know you did say at the time that the kids could come back and see him on a sporadic basis or something. He's now trying to establish some kind of parenting time. What's your response to that, ma'am?
He is asking for a lot of time. He's asking for pretty much all breaks and then 8 weeks of summer. I do not agree to that for the simple fact of it is they're still trying to get established here. My daughter, who's 14, she's looking for a job since she found out she can work at age 14. She's applied for a bunch of, jobs that she can work. She's doing driver's training in July. We're getting our son into sports. He's reading. We're doing like all math tutoring to get him established for 6th grade.
And I appreciate all that, but there is, when somebody moves away like that, it is very standard to give the type of parenting time that he asks for. I'm not saying I'm going to give it all right now, but you do understand that the kids are, 1,500 miles away or 2,000 miles away and can't have much contact. What are you suggesting? There's no reason that he shouldn't have significant time over the Christmas break.
We can, I would like to spend some Christmas with the children. But yeah, like I said, 2 weeks or 3 in the summer, but both kids have stated they're not comfortable staying with their father because they don't really have a relationship with their father. That they would feel more comfortable with his parents, who they do have a connection with and everything. But my concern is flying my children to Michigan with my son being autistic and my daughter only being 14. flying by
when
themselves.
you did have the motion, I do recall that you said, he could visit with the kids some in the summer and that kind of stuff. That was part of your request, and that was part of the reason that I granted it. All right. What do you, this summer's already started. I don't have a problem with this summer if he only had 3 or 4 weeks this summer. 3 weeks, maybe end of July, first 2 weeks of August or something like that. I don't know, because it's already started. Spring break, I would think would be appropriate for him to have. I would think he has a week over the Christmas break. Maybe every other Thanksgiving break. Certainly he should have time. Does he call the kids?
No, he has not called once since.
Why haven't you
Well,
called
he
him
called
ever?
once. He called once, but we were out paddleboarding, and then he never called back. And that was after I filed my response that he actually called.
So, have you attempted to get in touch with these kids since they've gone?
Yeah, I've tried 5 times, and a couple of the times the mom did not answer. And when she did answer, they said they were out Boris like paddle waving at some lake.
Do you have your call record of that?
I wrote everything down on it. I
Right.
kept documenting it and everything.
I mean, you realize you really haven't been a big part of your kids' lives. You know that, don't you?
Yes, I do understand that.
I mean, and now you want me to just send them here to, I mean, why haven't you been a part of their life?
I've been trying to contact, and I'm just not getting no answer from the mother.
No, I'm saying even before they left, you weren't much of a part of their lives.
I would see them, or I'd call them, and they would say, "No, Dad, I don't want to come." And so I assumed that they had something more important than coming.
Mr. Klein, I hear that kind of stuff all the time, and that's not any excuse, because I'm here all the time to enforce parenting time and all that kind of stuff. It sounds to me like you have just, you said, "Hey, kids, want to come over?" "No, Dad." "Okay, thanks, bye." And you just haven't done anything to be a part of their life. You haven't. I mean, the courts are here, as you know, to enforce orders. She came and asked for permission to leave and stuff like that, and you just really haven't been very much a part of their life. All right, and are you also still like $6,000 behind in child support?
I just started a job, and I've been paying my child support every week. Like, I've talked to the lady, Deb Mantis is her name, and we've already discussed on what I need to do and when I need to pay it.
So the answer is yes, you're still $6,000 behind in child support.
Yes.
I mean, all of this just tells me that you don't do much of anything with your kids. I mean, you left it up to the mom to support them 100% because you weren't paying child support. I mean, $6,000 you want her to pay for the flights here and back, but you owe $6,000 in child support, which I'd make her pay for the flights here and back if you were anywhere near current. But why? I mean, what's going on? You're just not showing very much desire for the kids.
Well, my understanding, Your Honor, was like the child support that I do pay is going towards the flight, so she wouldn't have to pay the whole flight.
The child, you're $6,057 behind in child support. Child support isn't supposed to. You've been for years. You're supposed to be paying child support, and you don't. Okay, you didn't accumulate. How much do you pay a month? What's the child support order, ma'am?
$530 a month.
$530 a month. So, I mean, you're a year behind.
The case manager told me it was $480, and then the extra $50 is going towards the rearage. So it brought it up to $540 a month.
All right. Well, until you get less than less than $1,000 in arrears, I'm not going to make her pay for all of the flight. It just that's just taking money from her that you owed to her for the past year or more. And $50 a month is what you're paying in arrears. And basically what you've said is, if I don't have the money, you just take care of everybody. And what if she didn't? What if she didn't pay for them? What if she didn't have any money? Kids starve and you just sit back saying, oh, well?
No, because I wouldn't allow that.
What? Okay, you wouldn't allow it. So why didn't you just pay it?
There's been
Because they weren't starving?
No.
And because you didn't think it was that important?
No, my kids are important.
But you don't see them and you don't pay for them. All right, ma'am, he's gonna be entitled to some type of parenting time. And you're gonna split the cost of it. I'm not gonna make you pay all of it. It's just the way it's gonna go. And it's gonna go that way unless and until you can prove, Mr. Klein, that you have paid a lot more, and you are significantly less behind in arrears. You can each split the costs. Ma'am, I would like to order that he gets 3 weeks in the summer to be exercised this year. I mean, because we're already in June. Maybe the last week of July and first 2 weeks of August. What time do they start school? I don't have any idea what Idaho does for school.
It's August 22nd. They start school.
All right. So I would suggest that maybe July 27 through August 17 or something in that area. That's 3 weeks. That's it. Parties will split the cost. And because it's so late, it might be more expensive than otherwise. He will be given spring break when the kids get out of school until they get back, and 1 week over the Christmas holiday. You guys can figure that out. All right. It's just something that happens, ma'am, when you move far away and the kids, all right. And you will, like I say, normally if he would have been current on child support, you'd probably be paying it all. All right. But he's not, then I'm not going to. So you'll split the cost. I give you that information ahead of time so that you can hopefully buy tickets farther in advance. They're always cheaper if you can get them farther in advance. Are you near like Boise or something, a major?
I am.
All right.
But right now, like I'm working, but I'm only in training. So I don't get paid yet because I don't have any clients coming in because I do dog grooming. So my thing is I don't have.
I could bring you my dog because I need it groomed.
Yeah, I'll be happy to groom them for you.
Little far, but
yeah. So I'm just trying to figure out how to get the flights, but
you're gonna have
the
to
kids
contact
travel, like, fly.
Mr. Klein. You find some cheap flights that go between. Is Boise the place that goes, ma'am? Is that where you'd fly out of?
Yes.
Boise to Grand Rapids. It's up to you and Mr. Klein to find in the next week appropriate flights for an appropriate cost. Contact Miss Perez. You guys work it out and how and what and when and all that kind of stuff. You know when you get it. Also look at 1 week over the Christmas break and spring break. You can give him the information if you can, ma'am, of when spring break is. And that's all I'm going to order right now. He will also be able to have telephone or FaceTime or whatever. Please make sure that some of that occurs. All right. You can't always answer and say the kids are out doing this. If he calls and wants to have that and the kids are out, say, I'll see that they're here at 7 o'clock tonight. Call back then or something like that. All right.
Yeah, I told him to go ahead and give me a call back and he just never called back. So I'm like, okay. And then for the flights, how would we work that out? Would he fly here to fly back with the children or?
Well, the 14-year-old's clearly old enough to fly. All right.
Yeah.
And the 12-year-old's also old enough. You just say he's got problems or something. What?
He has autism.
And is he unable to fly with his sister and by contacting the airlines and telling them and stuff like that? I mean, I fly enough that I see these kids and stuff like that. Does he need a person to go with him?
He's more comfortable when he flies. He gets anxiety attacks. Sister is pretty good at handling it, but not well enough. So he usually needs an adult to fly back and forth with him.
Can he get any just for the flight anxiety medication or something? I mean, just for the flight. I know a lot of people who take Xanax every time they get on a plane. Okay. but they don't need it in regular world. Can you just work with Mr. Klein to do that? If Mr. Klein, do you know enough about your son to know what his abilities are as far as flying and stuff?
With the flying part, I don't know because I never flew with him. It was always his mom flying with him.
All right. I'm going to tell the two of you to work that out. All right. If he needs somebody, you may have to take turns. You might have to fly out there to get him, and she may have to fly back here to get him back. All right. Just, this is what I'm going to order. And so make it work and try and make it work as efficiently and as least cost possible. All right. Understand? We'll enter the order and let's hope it works. All right.
Okay.
Good luck, everybody. Thank you. Hey up on your child support.
Yeah.
Good luck. Thank you. We're adjourned. Just been a plaintiff has never logged in. DP Lacy versus Tucker. Mr. Tucker is present and it's his motion. The plaintiff has never logged in. Mr. Tucker, how did you get her this motion?
I literally sent it through mail. The last known address that I had for her.
Did it come back to you?
No, it didn't.
Where did you get the last known address from?
From the court office.
From the courthouse?
Yes.
All right. She's never logged in. When did you send this to her then?
This was last month sometime.
All right. All right, this defendant's motion on child support wants to stop child support because he said mom and child are homeless. I don't know how you know that.
Recently, I'm sorry, yeah.
When was the last time you had contact with her?
I don't have contact with her much, but the CPS, literally Child Protective Services. This is not the first time, but this been numerous amounts of times, Your Honor, where I've had contact from the CPS telling me about the child and how the child is neglected. The housing that he's living in is not adequate, or abuse that's going on. And like I said, I don't have much contact with the mother. I just wanted to see, as you, I don't know if you can see those documents or not. I probably should have presented those, but there's documents stating that I even pay for child support for 2 other guardians that used to have, the child as well. So, and in this sense, like I said, at this point, we don't even know what's going on with the child. And I would like to get, keep getting investigating the situation before we keep on giving money to something we don't even know what's going on. Like I said, I just recently found out that they were evicted from their home, and their things were put out. And also,
are you paying child support? Because I know you're way behind.
Yes, I am paying child support, Your Honor. I fell behind a few years back, 5 years. I stopped doing my taxes, so I kind of fell behind. It's no excuse, like I said, but been paying, been making adequate payments, and I've been doing everything I'm obligated and required to do as well, and also work 2 jobs. So that's the issue. Isn't child support? I also pay for other children, so that's not the issue. The issue is the support of the child and the well-being of the child. I don't know. The child's been in so many different homes, Your Honor. CPS cases, numerous CPS cases, and all this is going.
And that's I'm not unsympathetic, except child support's child support, and you just pay child support, and unless you can tell me that the child is not with the mother. If the child's not living with the mother, I'll stop child support immediately. But if I don't even know what CPS is saying. All right.
Yeah. Okay. And like I said, I should have presented those papers to you, but
if you want to adjourn this motion for 2 or 4 weeks so that I get some information, that's fine. Otherwise,
yes, please. I mean, please. I would like somebody to look into it, Your Honor.
We'll adjourn this motion for 4 weeks and have you come back in 4 weeks. And if you can show me, like the child's not living with her or is living with a guardian or something like that, I'll either make sure the money goes to the guardian or it's stopped altogether if I can't figure out who the child's living with. All right. It doesn't eliminate your responsibility, but I'll give you a chance then to figure out a little bit more so that I have more information as far as if you're paying child support, where it should go. All right.
And just one more thing, Your Honor. I'm sorry. I know you're trying.
Oh, go ahead. Go ahead.
Now, I know I'm paying 3 different people on the same case, and this is why I wanted it to cease. It's one of the people that I found out were in prison, you know what I mean, for murder, and then the other guardian doesn't have guardianship any longer, but they're still collecting child support payments, you know, from when they had the child, when the child wasn't with the mom, when they were going to previous CPS cases before. So, you know, if it's not through the child, not through the you know, the mother itself, is it possible that we can still at least stop the other 2 guardians from receiving money out my checks because they don't have guardianship?
This is child support for Cameron, right?
Yes.
What are you talking about? Child support for other kids?
Oh no, for Cameron. I'm literally paying 3 different people out of the same case.
But you're only paying 1 child support, right?
Yes. And it's paying I'm paying rearages to people that don't have the child, and one, like I said, one of them is
rearages becomes difficult because I'm not really allowed to modify child support arrears. However, get me some information on this. This is a mess, and get me some information so that I can. 4 weeks from now, you'll come back, and I hopefully have better information. All right.
I will. Thank you, Your Honor.
All right. Thank you.
Thank you.
You got to renotice this.
Okay. So I have to come back up there.
Yeah. All right.
Okay. Not a problem.
Llamas
Thank
v.
you.
Llamas. This is mother's motion for custody. Says that dad has been now charged for, she says domestic is third degree domestic abuse. I don't know if it's child abuse or what, for hitting their child, who is Jacob, who is 5. Apparently, sir, do you have a no contact to the criminal court for Jacob?
Yes, I do.
What?
Yes, I do.
All right. Well then, and you are being charged. I'm not asking if you did it. Yeah, I'm just asking you. You have been charged?
Yes.
All right. Well, having been charged for assault against a 5-year-old, quite honestly, that provides enough for Vadvarka to set an evidentiary hearing. Ma'am, I can't change custody no matter what on a Friday morning. I can set an evidentiary hearing to change custody if you meet what's called Vadvarka proper cause or change of circumstances. Certainly, there are proper causes to have an evidentiary hearing that would include the domestic violence section of it, the length of time the child lived in a satisfactory environment, and the desirability of maintaining it. That would be proper cause there. There's plenty. Mr. Turner, can you hear me now?
I can. I'm all set now. Just having technical difficulties.
Is CPS involved in this case?
Yes.
Have you, are you filing a petition or what at this point?
No petitions being filed.
No petition, but you are aware that Mr. Llamas has apparently been criminally charged?
Yes.
All right. It's appropriate that we have an evidentiary hearing on this matter to determine proper for change of circumstance, as I've already stated, and proper cause for an evidentiary hearing on custody. We'll set one up as soon as we can. I know, ma'am, that you've also requested some type of child support. That'll all come out in the hearing, and any child support changes will be, I'll state, will go back to the June 1st date, but I don't know what is appropriate right now. All right. So we'll include that in the evidentiary hearing. Mr. Llamas, is there anything you wish to say?
I know that there's a no contact order, but I was instructed to at least put in that if there's a possibility of me getting visitations with supervision.
At this point, I'm not going to override that order, and in fact, I'm going to issue that a no contact order with Jacob and his father for right now. If you get that changed, do you have an attorney?
Yes, I do.
Is it appointed or you've retained?
I've retained an attorney, and
can you tell me who it is?
His name is Dan Wilkins.
Dan Watkins?
Watkins, there you go. Yes, sir.
All right. Mr. Watkins knows me well enough to know that if you get something changed which says you can have contact, he can file a motion here to look possibly at me changing that too. I certainly would not override and would not allow supervised parenting time, because if you did, you would violate your bond from court and you would be subject to going into jail. Okay, no matter what I said, that's a no contact, and I don't want you to do that. All right. So
yes, sir. He made me aware of that. He just asked me to make sure that I made it
Yeah.
clear that I was
So-
looking for it.
So, we'll issue a no contact. We'll set up an evidentiary hearing, as soon as we can and get to that. All right?
Yes,
Good
sir.
luck, everybody. Thank you, Mr. Turner. I assume there's nothing else that you kind of wanted to figure out what was going on, probably.
Yeah, yes, sir.
All right, thank you, everybody. Take care.
Thank you, sir.
Is this the last one?
No.
Why not? Did you tell him what I'm doing?
Yeah.
How many more? We have Sylvie versus Sylvie. Both parties are present, as well as Miss Van Tol, who represents Mr. Sylvie. This is plaintiff mother's motion for one uninterrupted week of parenting time, as well as change some exchange times. She also has a motion regarding cell phone for Jude, what I understand. I've read your request, ma'am, and I've also read the response. Is there anything else you wish to briefly add, Miss Sylvie?
Yes, I submitted some more exhibits to support.
Yeah, that was after, I doubt Miss Van Tol got appropriate notice of them.
I didn't receive them till Wednesday night, Your Honor. Thank you.
Yeah, but go ahead. What else, ma'am?
All right. In terms of changing the exchange time, I'm not asking for anything unreasonable, just
But you don't have any reason that the court should just suddenly start extending time. I mean, there's no shade, there's no Vadvarka. I mean, you can come in and fine, you know, you can ask for more, but I don't have any real reason to change those. You just want more time. And they oppose it. I mean, why am I supposed to modify that with, there's no proper cause or change of circumstance, even as it relates to the lesser case of shade?
okay.
Well, I'm just asking you, do you have any? You just want more time. You want like Wednesdays from noon till 8, but most of the time the kids will be in school during that time anyhow.
Right.
Then, you know, you want to extend Mondays till 8 o'clock. I mean, I know you want more time, but there's nothing that you have pled that would indicate something that the court should review that. And so I'm inclined to deny it because there's nothing other than you just coming in and saying, I want these times.
Right. I don't work in the summer. We engage in meaningful activities. It makes more sense for them to be with their mom than home alone in the summer.
All right.
So.
Well,
I'm
I
also.
don't find any findings under shade or whatever to modify the parenting time at this point, and would deny that. What else do you want with that? You want?
I was asking for a week of vacation to go visit with my sister. She's having her first baby. We'd like
Where's
to go.
Your sister
visit.
live?
She's in Connecticut. She moved about 1.5 years ago. 2 years ago.
All right. Well, Ms. Van Tol, that's probably the most reasonable of the requests that I have today for a short trip out to Connecticut. Can you tell me a reason? This would actually be a one-time deal. Ms. Van Tol.
Yes, thank you. Your Honor, the issue with the week of extended parenting time is that Miss Sylvie has been absolutely toxic and continues her toxic behavior throughout this case. And ultimately, the week she requested within the pleading, and I didn't notice this until just now, actually encompasses my client's weekend. So really what she's asking for is she's going to take the kids Friday all the way to a week later Monday.
No, that wouldn't occur. If she gets
Right.
any time at all, it would only include her weekend and would not include his. Tell me right now.
Right. And the week that she asked for is the week that worked for their schedule for Jude to take driver's ed, which she's taking. I know Miss Sylvie within some documents said that my client did this intentionally. It was not intentional. It was what was offered, what was available for Jude based on the schedule that they had available. And my client could ensure he was able to get there. So he would object to the week of vacation simply because of just how just absolutely toxic Scene has been. Unfortunately, as this court knows, we've been here several times because of her failure to follow court orders, her failure to co-parent effectively. She's lost legal custody since the parenting time and custody change.
You don't have to tell me that. I know all about this case, and I do know that I believe there's a contempt hearing that has been completed that may actually result in her incarceration because of the numerous contempt proceedings.
Right. We didn't ask for her to be incarcerated, Your Honor. Unfortunately, what Scene has done is she's really weaponizing the fact that my client's filing these show causes with the kids. So my client really asked for a delayed sentence. So basically, if Scene violated in the future, then she would go to jail. My client, again, does not want to alienate himself from his children because Scene is very good at that, as the court sees in Exhibit 1 to my pleadings. But at the end of the day, my client is concerned about her having a full week. If she's going to have a week, my client should have a week. He doesn't ever get a week of extended time with the kids because of her parenting time schedule. So those are really our concerns with respect to that request. And I would ask that if the court is going to entertain it, like the court indicated, it would be a one-time deal and not more than this.
Well, it would be a one-time deal. And if there would be a better week, because I don't want to interfere with his driver's ed. I know what kids are like with driver's ed and stuff like that. If it's the week before or the week after, something like that, I don't know. Is there a better time?
It would really kind of have to either be the week before. The kids start school in Comstock Park on the 19th. So based on the week she requested, which I believe is the first full week of August, that doesn't really leave much more time. And because that is that piggybacks off of her weekend, she wouldn't be able to take that extended time. So basically, if she wanted a week, she would have to start the week prior and go to the Monday her parenting time ended.
When do you want to go out there, ma'am? You have tickets or what?
No tickets yet, but Your Honor, in terms of the driver's ed, Jude was signed up. There was no discussion, and he was registered after.
He doesn't have to discuss it with you. You don't have joint legal custody anymore. You lost that by your actions.
Okay, I understand. So she is due on August 2nd. We really can't go early. And
you don't even know she'll have a baby on August 2nd. She could be, what if she's 10 days late?
Well, doctors don't typically let you go past your due date.
Well, I'm sorry, but I know many kids who were born late, so that's not true.
I could get a doctor's note from her to support that she won't go past her due date. School starts the 19th.
I take them out there for an extended weekend. You have Fridays through till Monday morning. Why can't you, Miss Van Tol, let her take a Thursday or something, or Wednesday through, or through the weekend and stuff like that, the weekend that she has, and it'd only extend a day or two. Is that acceptable?
Can I interject? I'm sorry. Noah has camp that he's been registered for the week prior, leading up to the Friday of her weekend.
So
he's going to be a sleepaway camp for that week prior.
Matt, what about, and again, sorry, Your Honor, this hasn't been discussed with my client, so I want to just talk with him about this really quick. Right. Her weekend would be the 15th through the 19th.
Let me ask
the 16th.
this, all right?
Yeah.
I'm gonna deny the request, but ask that you see if you can find a time, maybe a couple extra days or something for the kids to go out there. It would not be inappropriate for the kids to go. I'm just trying to say, hey, kids, you get to go to Connecticut and this kind of stuff. You admitted that they have a relationship with the aunt and things like that. If you can do that and add a day or two, do that. All right, Miss Van Tol. I'm going to deny the request basically on a lot of what you have said. I know that Miss Sylvie just constantly is before the court for violating court orders and stuff like that. And it's not necessarily appropriate to give her a whole bunch of time for her to continue to do what she's done. I mean, she's lost custody. This is nobody else in my 8.5 years has lost and done this kind of stuff. No mother has gone through this, but she constantly sets herself up for failure and constantly gets in front of the judge for it, and constantly is fined for it and things like that. I don't understand, but I will deny it. I'm just gonna ask you, Mr. Sylvie and Miss Van Tol, to consider letting the kids go for the extended weekend or something. Maybe they go on Wednesday and come back on Monday, or Thursday and come back on Monday. If that's good. I'm not gonna order it though. You understand what I'm saying?
I do, Your Honor. Can I just have a little, again, because of the way Cena deals with these orders, I just want to be clear. If my client provides her this additional time, would he receive some makeup time for that?
I'm not even as concerned about that, but I do want an order entered if you agree to something before she goes, so that there is a court order. Right. 'Cause I'm not going to take the chance it doesn't come back or something.
And then, Your Honor, I just, again, I'm not trying to belabor this, but because of the way that Cena has been pretending to be ignorant of these orders, we have issues with her picking Jude up early from school just very recently. The order specifically indicates that she can pick the children up from after school or as early as 3 p.m. She picked Jude up without communicating with my client during a half day. He does not want to continue to keep doing this. And then he had Noah until much later because Noah wasn't out of
Orders
school.
are the orders. I'm not going to modify them at this point.
Okay.
Right? I mean, I'm not going to get into 15 minutes here and there. The order is the order and has to be followed. All right. And I'm not going to mess around with orders, ma'am, because you mess around with them enough on your own and find yourself in trouble. And the order is the order of the court. It's the one that I will, and Judge Hillary will enforce. All right.
All right. I have
The other request is for access to a cell phone and this kind of stuff. You give the example of your son being at AJ's and not being able to contact them or whatever.
Yes.
Doesn't his phone ring? Doesn't he have a text ability?
Yes.
Why didn't you call him when he wasn't at AJ's or something like that? Why do you need all this other stuff?
Well, I need consistent access to his location, the same access that Matt does on his.
Why do you need access to his location? Call him. He's not there. Where are you? Text him. I'm on my way to pick you up. Where are you? I mean.
Yes, we did do that.
All right.
My case is that I shouldn't have to rely on Matt during my parenting time. Let's say Jude doesn't have access to his phone. Like he can't call or he's not answering his phone like a teenager. I should be able.
He's with you at the time that you're complaining about it. And if he doesn't have his phone, you'd know about it.
Right. So if he does have his phone, and he's not answering, like a teenager maybe doesn't answer his phone.
I don't answer all my calls and you don't get a chance to know where I am and stuff like that. Mr. Sylvie gets to set the parental controls, and the phone is just the phone that will remain as the phone is. If you want to work with Mr. Sylvie for something, but I'm not going to change any. We had a whole hearing on this because you basically abused cell phones by giving him one that he was not supposed, he was hiding it and all this kind of stuff. He's got one phone. That phone will be available for phone calls, for text, whatever else that Mr. Sylvie gets to do what I want to say, parental controls and stuff, but it comes over to your house. You'll know what the parental controls are on it.
I don't know. I don't have access, Your Honor.
You got the phone.
But I don't have access to his location. So on my own parent, it impedes my ability to maintain their
impede your ability any more than, what about when my kids were growing up? I never had access to them because they didn't even have a phone. They had no phone. They were too young. You call him and ask him where he is. If he doesn't respect you enough to answer the phone, then work with it. I'm not going to change anything on the phone.
So if Jude and I have another app that we use so I can consistently access his location. Matt, on my parenting time, has the authority to change the parental controls with app access.
You've abused so much stuff from the court and orders that the court have provided over the years and have consistently gone against them. I'm not comfortable giving you any more access. You can call your son, you can text your son, you can do that. That's what parents do, and that's what you'll be allowed to do. He is not allowed to prevent you from having you to have access to the phone so that you can call and text. That's the order. I'm not going to grant your other shared access to, other stuff during parenting times. Anything else?
Oh, yes, sir. I just want to make sure I understand. So,
I'm denying your motions. There's not much else to explain.
all right.
Ms. Van Tol, you can draft the order. Thank you very much. We're adjourned.
Thank you, Your Honor. I did ask for fees. Is the court
Uh,
at all going to entertain a fee request?
um,
I'm asking for $750 for today.
not at this time. No, I'm not gonna grant fees. She's got problems, up at the order to show cause hearing that you got. I'll remind me if another motion similar to this comes up. They're not frivolous motions at this point. I don't find them to be frivolous. I'm just denying them. Just because I deny them doesn't mean they're frivolous. And so I'm being kind and no at this point. Thank you.
Okay, thank you.
We're adjourned. 3-DM Peard versus Peard. Both parties are present via Zoom. This is mother's request for child support. There was a recent order in February for child support. This has apparently been paid up because he paid some $840 back last August and he only has $38 a month. So he's paid up and she wants to increase child support. Sir, are you working yet?
I'm not working yet, no, but I just started getting VA benefits.
Okay.
So I'm not opposed to doing a report income thing for the FLC.
Report it to the friend of the court. I'm going to refer your case to the friend of the court for a recalculation of child support, ma'am. That's what I'm going to do. All right. Okay. You understand that, sir? So you'll give him that information and.
Yep. I've already spoken to them about it. They said just to wait for you or for this to get a court order to.
All right. Do it. I'm going to do it so that we'll take a look at it, ma'am. All right.
Okay.
Good luck.
Thank you.
Thank you.
Thank you. Bye.
Thank you.
Mr. Wiley, can you hear me?
Yes.
Did you give notice of this motion to Miss Andrews?
Yeah. I went to her work.
You what?
I brought it to her. She was at work.
So you handed it to her?
Yep.
When was that?
When? Last Friday.
All right.
A week ago.
All I need to know. Oops, almost read Ostrander versus Wiley. This is a motion by the father, Mr. Wiley. Hold on just a second. I'm trying to find your notes here. All right. It's a fairly simple motion. Quite frankly, Mr. Wiley's saying that mom keeps coming and picking up the kid and telling people that she's got custody. Yeah, find them now. Case. When in fact her rights have been terminated. That's what I mean. There's an order in the court file that her rights are terminated to the child.
Yep.
And that's in an NA case 16-53770. She has no rights to that child any more than I have to come pick the child up. All right.
Correct.
Or have somebody else come. So, I mean, I don't really know what you want me to do because, I can issue an order that she's not to have any contact with the child.
No, she has all of his stuff now.
Yeah. Well, you know how that's going to be to get it back. I'll issue an order that she is to return all of the child's stuff to you by next Friday. Okay.
Okay.
All right. Good luck on getting it, I'm sure. But we'll issue that order. As far as the rest of this, I'm suggesting that you might want to go, and I've already told Judge Hillary's clerk, get a personal protection order for you and the child, Aiden, that she is to keep her away from him. So then if she's around him at any time, it's not like the police are going to go, oh, maybe she does have custody. All right. I'm suggesting you can fill out a form online, getting a personal protection order through Judge Hillary to keep her just away.
Okay.
You and the child. She doesn't have any rights. She doesn't have any more rights than I do.
Correct.
So I'm hoping that maybe through a personal protection order, if she comes by again, the police will know that she's not supposed to have any contact with Aiden or you. All
okay.
Right? That's the best I can do for you. I'll issue an order that she is to return the items listed in the motion to you by next Friday. And then the rest is up to you. All right.
Okay.
you got a bad situation and I'm trying to help, but I can only do so much. All right.
Right.
Good luck to you, sir. Riley.
All right, thank you.
Thank you, Charleston. You have a video?
You asking me?
Yeah.
Okay. No, you don't see a video on me.
Let me see.
All right.
There we go. Okay.
All right. Mr. Charleston is here. It's his motion regarding custody. Mr. Charleston, how did you get this served upon Miss Riley?
I went down to the further court and they had to mail it off to her. Or
right, to a confidential address?
Yes.
All right. When was that done? I mean, you filed this before. You re-noticed it for this time. It was filed for 2 weeks ago, as I recall. But she was.
Yes, we had tried to we had tried to get on there before, but we weren't successful.
All right. You made a motion here that says that the mother was in a serious car accident, was in critical condition and non-responsive and stuff like that. What's her situation right now?
Right now she is responsive. She is
Long-term nursing facility.
at the long-term nursing facility. She have to wait like 10 more weeks before she goes to rehab. She had broken both her legs, her arms, 5 ribs, her nose, pelvis, you know, a lot of things.
All right. All right. And she's aware of what you got Malachi, who's 11, right?
Yes, Mackay.
Oh, I'm sorry. Mackay. Yes, I didn't read it right. All right. I can't change custody here today, but I will certainly give you an order that gives temporary custody to you of Mackay. Okay?
Okay.
And we can set up an evidentiary hearing somewhere down the road. I mean, there's got to be parties who can get in this and figure what out. I mean, mom obviously can't be taking Mackay while she's in a nursing home or something like that, rehabilitating and whatnot. All right. So the order right now, I'm going to give you temporary legal and physical custody of Mackay, pending an evidentiary hearing, which you'll get notice of. She will get notice of, and let's figure out what's. I mean, are you able to talk to Miss Riley and anything like that?
Yes. I will be taking him up.
You guys need to kind of figure something out in the best interest of Mackay at this point. All right. She's got to know she can't.
Yes.
But I'll give you temporary legal and physical, and we'll set up an evidentiary hearing because I can't change it here today. But you will have. Are you paying child support?
Yes.
I'll suspend child support also. All right. That's probably the best I can do for you on a Friday morning, but it's not.
Yes, that'll work. I appreciate you.
All right. We'll suspend child support and we will issue an order giving you temporary legal and physical and set up an evidentiary hearing. Look in the mail for when that hearing is going to be and stuff like that. All right.